Can you get sued as a freelancer in Australia? Dodgy mistakes to avoid. What if I told you that as a freelancer in Australia, you could be sued over a simple mistake, one you didn't even realize you made? Imagine this. You've just landed a high-paying client, delivered your work on time, and everything seems perfect. But weeks later, you receive a legal notice demanding thousands of dollars in damages. Your heart sinks. What went wrong? Could this happen to you? Freelancing offers freedom, flexibility, and the ability to be your own boss. But with that independence comes responsibility, especially when it comes to legal risks. Many freelancers assume that working solo means they're safe from lawsuits, but that's far from the truth. Australia has strict laws that apply to businesses of all sizes, and even a one-person operation can be held accountable for breaches of contract under contract law, intellectual property disputes under the Copyright Act 1968, defamation claims under the Defamation Act 2005, or even consumer protection violations under the Australian Consumer Law, ACL, which is part of the Competition and Consumer Act 2010. See, let's say you're a graphic designer. A client hires you to create a logo, and you use an image from a free stock photo website. Later, you find out that the image wasn't actually free for commercial use, and the original creator is now suing both you and your client for copyright infringement under the Copyright Act 1968. Or maybe you're a copywriter who unknowingly includes misleading claims in a sales page. If those claims lead to financial loss for consumers, you could be held liable under the Australian when it comes to contracts, or the lack of them. Many freelancers rely on verbal agreements or hastily written emails to outline project terms. But what happens if a client refuses to pay, disputes your work, or accuses you of breaching confidentiality? Without a solid contract in place, you could find yourself in a legal gray area, struggling to prove your case. And then there's defamation. You might think defamation is something that only affects journalists or celebrities, but freelancers who publish content, whether it's a blog, a social media post, or marketing copy, can also face lawsuits if their work damages someone's reputation. Even an innocent mistake, like misquoting a source, can lead to legal trouble under the Defamation Act 2005. But here's the good news. These risks are avoidable if you know what to watch out for. In this video, we're going to break down the biggest legal mistakes freelancers make and how to protect yourself. We'll cover essential contract terms, how to avoid intellectual property disputes, and why business insurance might be the safety net you never knew you needed. So, before you send out another invoice or take on a new client, stick with me, because understanding your legal risks could be the difference between a thriving freelance career and an expensive legal nightmare. I'd love to hear your thoughts. Have you ever worried about getting sued as a freelancer? Or maybe you've had a close call? Drop a comment below and share your experience. I read every single one. And if you're finding this video helpful so far, hit that like button so more freelancers can get this crucial info. Plus, if you want to stay ahead of the game with legal tips tailored for Aussie freelancers, make sure to subscribe to Aussie Legal Insights and turn on notifications. Now let's get into the biggest mistakes freelancers make and how you can avoid them. To understand why freelancers can be sued, we need to take a step back and look at how Australian law treats independent workers. Think of freelancing like renting a house. When you rent, you don't own the property, but you still have responsibilities, like paying rent on time and maintaining the space. If something goes wrong, you could be held accountable, even if you didn't intend to cause any harm. The same applies to freelancing. You don't have the backing of a big company, but you're still legally responsible for your work and business dealings. Australia doesn't have a single unified set of laws governing freelancers. Instead, freelancers fall under multiple areas of law, including contract law, intellectual property law, consumer law, and even employment law in some cases. Unlike employees who have protections under the Fair Work Act 2009, freelancers operate as independent businesses, meaning they don't have automatic legal protections if a client refuses to pay or if they're accused of freelancers have is that verbal agreements or casual email exchanges are enough to protect them. Legally, a contract doesn't always have to be in writing to be enforceable under Australian contract law, but proving the terms of a verbal agreement in court can be nearly impossible. That's why written contracts are essential. They lay out clear expectations for both parties and provide legal protection in case of disputes. Another important aspect to understand is liability. Many freelancers think that because they're a one-person operation, they can't be held liable for damages. But in reality, if a client suffers financial loss due to your work, whether it's a marketing strategy that backfires or a website design that causes security vulnerabilities, you could be sued for negligence under Australian common law. law. This is where business structures come into play. Operating as a sole trader means you're personally liable for any legal claims against your business. On the other hand, setting up a company under the Corporations Act 2001 (CTH) can provide some level of legal separation between your personal assets and your business liabilities. Intellectual property law is another area where freelancers often run into trouble. If you create content, whether it's graphic design, writing, photography, or coding, you automatically own the copyright to your work unless you sign a contract transferring those rights to a client under the Copyright Act 1968, Commonwealth of Australia. However, using third-party content without proper licensing can lead to legal disputes. Even something as simple as using a Google image in a client's blog post without permission of misleading and deceptive conduct. Under the Australian consumer law, businesses, including freelancers, must not engage in conduct that could mislead or deceive clients or consumers. This means that if you overpromise results in your marketing materials, exaggerate your experience, or fail to deliver work as described, you could face legal consequences. Understanding these legal concepts might feel overwhelming, but they're crucial for protecting yourself as a freelancer. Think of it like driving a car. You don't need to be a mechanic to operate a vehicle, but you do need to know the road rules to avoid accidents. By knowing your rights and responsibilities, you can navigate freelancing safely and confidently. Now that we've covered the legal background, let's break down some of the most common myths and misconceptions about freelancing law in Australia. If you found this video helpful, don't forget to like, subscribe to Aussie Legal Insights, and share it with your mates. More freelancers need to know this information to stay legally safe.